Welcome to our motor vehicle legal report. Today's date is January the 23rd, 2023. We have our Chairman Roberts present, Chairman Jackson, Commissioner Galvin, Commissioner Norton. We got Commissioner Kramer, Commissioner Levy. We have Director Lawrence. We have Jason. We have the Attorney Smith, Attorney Kelly, Attorney Taylor. I think I saw Bob Weaver somewhere in the audience. Got a couple of people in the audience. I didn't recognize their name back there, but I see Commissioner West back there. Let's see. Did I miss anyone? Who? Oh, I'm sorry. Morning. With that said and done, we're going to get started with our legal report. I guess I'm up first. I guess number 6. On the report, and I can't remember who had number 6. Okay, just got a clarification. I saw where we charge $5,000 for unlicensed activities. Just for clarity, I didn't see how many cars were sold by the unlicensed.
Yeah, it was. Let me do the math really quick to remember exactly how many it was. It was 10.
10, okay.
Yeah, so 500 per.
500. Okay.
Sorry, couldn't remember the exact math.
That's okay. I just wanted to make sure. I got another question down further, but I'm gonna turn over to my colleagues. I know these guys always have some questions, so I'm gonna start out with Chairman Roberts. How about yourself?
I'm going to defer to these guys, let them go first. Okay. And we'll just come around this way.
We'll just come around the bend. How about that?
All right, that sounds great.
Good morning, Commissioner Norton here. I've got just a few. Case number 18 had a fine of $500 civil penalty. I didn't understand why he was fined. I know they said they didn't know how many temporary tags, if that was a problem, but deceptive and deceptive acts, I wasn't sure what that was. There's delay in paperwork, but I didn't see fraud as being a part of the delay in paperwork.
Yeah, so depending on how long the delay is, in the past we've issued a fine under that statute. That's kind of like our more broad statute that offers some kind of repercussion for extreme delay in title. And this one was, we had talked about this one before. We'd gone back and forth whether or not issuing a letter or assessing a fine, but just due on the extreme amount of time, we kind of felt a fine was appropriate. So that way it would maybe move things along faster, and then the next scenario.
Was it George's or the dealer's fault?
It wasn't clear. I think it was 50-50. I think it was some of them not moving their paperwork through, and then some delay on Georgia as well. But I'm open to whatever. We had discussed this one too. We had gone back and forth on it.
As a dealer, I understand that there are title delays. Of course, COVID created a lot of those situations, but it's just a challenge as it is. And as long as the dealer's acting in good faith, I just don't see where fraud is a correct label for that. My opinion, I just don't. There ought to be another category for that to go in.
Yeah, I understand. Yeah, that's just the one that we do it under. As of now, there's just not another category to get somebody under a title situation for.
Probably more like deceptive.
Yeah, deceptive.
Not really
the name of the statute is false, fraudulent, and deceptive. So it doesn't have to. Yeah, so it doesn't necessarily mean fraudulent. It's more of communicating the title issues or taking steps. Like at the point of 10 months, he should have taken another step to either undo the deal or kind of things like that. And so that's what it's falling under, that deceptive maybe more than fraudulent.
That's the normal business practice to have title delays. And failure to maintain proper business processes, something like that. That's where it falls under. But like a vehicle, you get failure to maintain control. Well, you had a wreck.
Yeah.
Simply was you didn't pay attention to what you're doing. That's what a dealer has to do because we deal with this every day. I do. We have 7,000 transactions. I'm going to say 10% of those have title delays that create problems. I'm not doing anything deceptive or fraudulently. I'm just having a business practice problem.
Yeah,
and it's very common. It's one of the common threads in our what we read in all these reports: title delay, temp tag. How do you handle those situations? So it's worthy of categorizing it properly because it's never going to go away, and it's only going to get worse as a result of what we just came through with COVID. We saw that we're having to extend temporary tags.
So if we just were talking about this, if we want to find them, there isn't anything else that we can find them under this other than this category of statute for this particular issue. But if you don't want to find them, we can vote on that.
No. I think a dealer should be responsible for doing what they're supposed to do.
Yeah.
It's our duty as a dealer to protect our customer,
Yeah.
make sure they get their documentation for registration in a proper amount of time. If we don't, we have an obligation to do certain things to protect them, and that's what we should. But fraud was just a strong word for this case.
Yeah, that's just the name of the statute. Unfortunately, it's,
Okay,
but
all right.
And would you-
when
would
you
you-
when no, I understand what you're
Would
saying.
you
Yeah, when
rather
you
do 250 on it
No,
instead
no,
of 500? Or
No, I'm not concerned about the fine. It's the title.
It's just the wording.
It's just not a fraudulent act. It's an irresponsibility based on market conditions. But anyway.
From my point of view, selling a car without the title and then allowing that that
10 months
problem to be a burden on a consumer for 10 months can be, I think, considered a deceptive act in the business of selling cars. And it's a very broad statute.
Mm-hmm.
Unfortunately, we just don't have anything else, not even close, that we could put this under. So I mean, it's an idea that we could always put that in our statute or rules.
Yeah.
It's worthy of noting because it is a common
It's the
thread
most
in
common.
yeah,
our,
it's very
in
common.
our
Yeah.
reports here.
And
That would be like creating a new rule.
Yeah, I mean, I think it would be
Yeah.
worth consideration.
I think the Rules Committee could take that one up. They hadn't had anything to report in a while.
Okay, so no changes on that one though.
No changes
Okay.
on that. No changes. And I've just got one other, but I will point out, and there was some discussion earlier about the job the staff did. This is a very clean report, and I thought it went really well. Take a lot of work, a lot of reading off of us, and having to reread. So it was very clear. I did have one to point out, though. It's number 55, and it's just a conversation about the fact that Carfax was noted as incorrect. And for the staff, I wanted them to understand that I've always maintained that Carfax is mistaken for the gospel from time to time. And it's just a vehicle history report, this gathered by data that's not always accurate. And I find it as a dealer that's consistently inconsistent with its data. So I just thought I'd point that out for everyone to understand that Carfax is a good reporting, and it does serve a purpose for consumers, but it's not something we should make a decision on without further fact-finding ourselves.
Right. No, and I know you've mentioned that before. I always include it just because I want the commission to know that is maybe why the complainant is confused. And that's why we don't discipline when the Carfax is wrong. I just want you to know, like, that's sometimes it's what leads to a complaint because the consumer doesn't understand that. So
Complainants often
more,
cite that.
yeah, I more so include it so you know why we're closing it without action.
Well, I feared beating a dead horse there, and I did. But I just had to take advantage of that. So my apologies.
Have something to talk about.
My apologies. Yeah, I do. You didn't give me anything else to talk about. So there was a little bit of skipping between 62 and 63, and I didn't know if there's something to clarify on that as far as case 62, 63. It could be a typo on mine, but it looks like we went from 62, 63, and there was might have been just me. I'll
One more case, it looks like, right below it.
Yeah, it
that
did.
was like a continuation. So
Oh, there's two under 62 because there's two separate complaints against the same dealer, so we put them together. So there's that first one that ends in 511,
Yep.
and then a second one that ends in 111, and then it goes to 63. Is that?
that's it.
Yeah. So those are the same dealer.
I kind of thought so.
Yeah,
but,
they're just it's just kind of easier to link them together.
we assume that dealership is still issuing paper tags.
Yeah, or they found a way around the system, so it's one or the other. One thing that they're not supposed to be doing, one way or the other.
But I will say, and Denise had a conversation with the director over at the Department of Revenue, and she told us that the Easy Tag system is supposed to prevent more than, at this point, 2 tags from being issued because they have one and they're allowing an extension right now. But I feel like there's a disconnect there because I've seen Easy Tag systems, dealers figure out a way.
Mm-hmm.
I don't know if they're using a different date or a different
I think
bin.
they're
I don't know what they're
changing
doing,
things
but
to get
there
around
is a way, and we let Alice, or the director, know that. So I mean, that's kind of all we can do.
Okay.
But they could also be using paper tags
Yeah,
because they haven't prohibited that as of now. I guess if dealers still have them, they're allowed to use them.
They had to realize there is a way to cheat the system. They need to be put on notice because there is a way to cheat the
Oh,
system.
they are. I mean, they've been put on notice more than once.
And they've asked us to start alerting them in these situations
Yes.
on a certain dealer, so they're going to start looking into
Good,
it now. Yeah,
good.
so we
Yeah, actually, we just had that conversation right before the meeting that we are going to start kind of keeping a spreadsheet of dealers that are coming up if they issue
multiple.
more than 2 right now, and then when the extension goes away, if they issue more than 1, we will let them know what dealer is doing it, and they can look into how they're doing it.
What's the penalty for that dealer to getting caught cheating? Now, to me, that's fraud.
Well,
It
right
would
now
be.
it's always been 500 per
Yeah.
tag with us,
Right.
but who knows what the Department of Revenue can do?
Yeah.
yeah
I'm sure they can
pull their
Okay.
they can pull their
access
use.
and things.
That concludes me.
Finish.
Yes, I'm through. Thank you very much.
Great job.
Good morning, legal team, and I confer with all my colleagues here that very good, clean report. I do got a couple of comments and suggestions on number 14. I had to read that twice. The complaint comes in and says that he has a warranty. He bought a warranty, and then the respondent comes back and says, no, there's no warranty on file. Then you read down further, and it says, yes, after he comes in, the car is repaired, all of a sudden there is a warranty that the guy gets. I'm just confused of what happened on this deal because there's just too many odds and ends, and we just need to clarify some of that.
Yeah, it was a lot of going back and forth in both the complaint and the response, and so at one point, I think they were both confused, and I think they had confusion.
How can they be both
Well,
confused?
I'm sorry, confusion in their conversation. Like, I think, their responses to each other in their actual filings.
The respondent says
Yeah.
he went back and looked at all the records and says, hey, there's no warranty whatsoever. You do not buy a warranty. Then down at the very end,
That's what the complainant is saying that they said to her in person. The respondent is saying they never said that to them. So, I mean, that was a conversation, an in-person conversation between the complainant and an employee of the respondent. So, I mean, I'm not sure if that
there's two sides. and
occurred
I
or
get
not.
it.
The respondent in their response is saying, this is what they have. They've always said they had this. But they're saying, the complainant saying, we went in to get our car fixed. The mechanic told me, I looked it up. You don't have anything. If that happened, I'm not sure. But that's kind of why we wanted to issue a letter of warning, just because they are saying different things, but it's still putting something on file that we're aware that this was a possible issue.
Okay, so clear on that. Case number 20, I thought was very interesting. The fresh start credit. Apparently, this dealer has been in trouble before or had some penalties, civil penalties. But I'm just thinking, I'm trying to figure out why just $750 civil penalty on this particular case. I think it should be more. I think maybe they need to come to the board. But to me, this thing is just absolutely not right.
And we talked about this one, and we are not opposed to it being more. We kind of went back and forth. So if the commission thinks it should be more, I could be in agreement with that. Or if you want to skip offering a penalty and have a hearing.
Based on the past of what we're seeing right here, and
Yeah,
and it is false advertising. I mean,
yeah, their website that's a very big part of it is them getting people in the door because they have bad credit, and from what it looks like to us, it's a promise that we are going to get you in a car, and that's not happening with everybody. And this complainant in particular drove 3 hours because they were promised. The respondent put them up in a hotel because I'm sure they realized how bad that looked. But I think whatever the commission thinks is appropriate due to their history. I mean, they've technically not had an advertising violation, but they've had some big issues, and I think that it can be appropriate for
we're
us
going to send them a letter, and it's like a slap on the wrist. $750, okay, no big deal. Let's continue doing what we're going to do. I mean, I promise you, they're making money, but sooner or later, we've got to put an end to this thing.
Yeah, and we could take that opportunity to do whatever you think is appropriate.
I agree with Alvin. Can I ask, has this dealership been before us before here, present?
No,
Or
because
never?
they've agreed to our settlement offers. So
Oh, okay. Yeah.
They've signed 1, 2, 3 consent orders. for different things, but they're all obviously they're not getting the message.
Isn't it a red flag? Red flag. I mean, what does that tell us? I mean, we can continue doing this. I mean,
So we can skip offering them a consent order.
the hammer to the
They're
nail.
probably going to sign it.
I mean, let's
Wow.
let's get their attention. I mean,
But can we have the fine and make them come before us? $1,500 fine, and you have to come talk to us.
oh, absolutely. I mean,
We can do a consent order with whatever fine we decide is appropriate, and requiring them a term of the consent order that they have to show up at the next meeting, for instance. Now that wouldn't be a hearing, where you wouldn't be able to take any more action then. If you want the option of taking more action, we would need a hearing. If you wanted to talk about, taking action against our license, we'd have to just set a hearing. So you can do either of those.
Well, it's important they be compliant. I know, for example, if you're not compliant with the FTC and they get summary judgment on you, they park somebody on you for 10 years at your expense. So I guess what Jim's saying is they need to be held accountable, and it looks like on an ongoing basis they're reluctant to be compliant. The fines are insignificant, so they need to be put on notice and observed. So
Yeah,
it'd be nice if they come here and explain this, and we explain to them what their expectations are to operate in the state of Tennessee. As a
we want the explanation and the reasoning because of what you've done in the background. Bring it to us. Tell us.
Okay.
We're going to follow, and we're going to make sure that it does happen.
So we'll
We're gonna have a hearing or not? No.
require them to appear,
Okay.
and you are able to talk to them about whatever you want, ask any questions, and then also put them on notice of what needs to happen and what needs to change. And then also we can decide what fine is appropriate right now.
Yeah. So the $750 civil penalty, is that is that the normal fine for a civil
So
penalty?
the $250 portion of that is the normal fine for a first-time advertising violation, and then we added a $500 false, fraudulent, and deceptive act for kind of fraudulently and deceptively saying they're going to get you in a car. So that's how we got to the $750. But again, we really weren't. We were kind of open. We weren't sure if we should do more because technically this is the first time they're in trouble for this thing, and traditionally, when it's your first time with a certain violation, we give you the bottom line offer of a civil penalty. But they've had a $5,000 civil penalty for other false, fraudulent, and deceptive
that's what
practices.
confused me right there.
So we could do, we could do another 5,000. We could do a 5,000 for the deceptive practice and a 5,000 for the advertising violation, which would be a 10. I mean, really, you can do whatever you think is appropriate because this isn't their first time being in
I think
trouble.
we need I recommend that we bring them in, have them talk to us. We raise the $750 civil penalty to $1,000.
Okay.
And then have them come in here and explain to them what they're doing. Okay. Based on what we've seen so far. Is there any objection?
Oh, I'm okay.
Yeah, you could charge per day. You could charge per month. You can, this one is just, we only have one instance of a consumer complaining about it. And it's just on their website. So it's not like we have multiple, proof of multiple times this has happened to somebody. But again, it's on their website, which is up every day. Yeah. And God only knows how many people are seeing it. So
Erica, I think he's talking about multiple violations in the past.
Yes.
Like,
5,000 is the most we would.
Right.
That's the highest that we've gone in the past.
no, I think he's saying because they had one for 500, one for 1,500, one for 5,000. Can't we say based on your prior activity, this is a pattern? Though this was only one complaint. Do you see what I'm saying?
Yeah, yes, we can. We can multiply it.
I mean, here it is. The proofs of the pudding right here. Now tell us why.
Doesn't mind paying the penalty. He'll pay that.
Well,
But
yeah.
once you ask him to come in and explain his action, how he's dealing with the consumer, That's a
I
different
kind of
story.
like $12.50, so $2.50 for the deceptive act and $1,000 for the prior activity, and come and appear before us. That way, we're
Okay with that.
We're fining you $1,000 for that. We have to deal with you again. $2.50 for the underlying violation.
Yeah,
With that.
12.
agree?
Mm-hmm.
Okay.
Long?
Case number 39, just real about dealer tags getting fined after 72 hours. And I don't think that this person should have got a letter of warning because they had a dealer tag over. Discuss this as
We did. We have, yes. Because they had already issued 2 temporary tags, they knew they couldn't issue another one, so they put their dealer tag on the consumer's vehicle that they bought until they were able to, get the registration and title.
That is showing a sign of taking care of the consumer, and it's putting it on the dealer's insurance too.
Yes. Well, I'm not in disagreement with you. I don't have an answer for that. I think, yeah, I mean, they could have put them in another car or, I don't know. I don't, we all talked about this one as well. We were very aware that we have had this conversation in the past. And if you are the experts, you are the dealers, you deal with this. We're not the ones that are in the shoes. So if you don't think this is appropriate, then I'm fine with that.
as a dealer, we're liable because we have the dealer plate. But I think as a dealer, he was taking care of the customer. And this point in age, with parts being unavailable for X amount of time, whatever, we have to take care of customers. I mean, it's just
That's right.
With recalls and everything else, we got to do what's best for us. And the 72-hour rule, it's just, I thought,
Well, as far as I know, it's been explained to me that a dealer can go to the clerk and apply for a temporary operating permit. And if that's approved, then I don't think there is a time frame on how long you can use that, as long as they allow you. And I think you give them the circumstances of why there's a delay, and they can decide to let you have a temporary operating permit. And there's a statute for that separate from temporary tags, and that's under the Department of Revenue. So I've heard of somebody doing it once. I think it's just not known. I think a lot of dealers don't know it's an option. But yes, they could have done that. They could put them in a rental car. Unwind the deal, but I've heard a lot of times consumers don't want that.
It's just something
They could have offered it, right? So
This is the category. It goes back to the case I discussed about deceptive acts. It's about all related to getting a title, probably. And I give the consumer is the most important thing that we represent. And I think it's up to the consumer, because I don't put a dealer tag on a car, because in previous commission meetings we disallowed that. And I think we favored to go back that way. But to me, the options are unwind the deal, because we're supposed to have the title when we sell the car anyway. Right. Okay. And then we either unwind the deal, put them in a loaner car, or put them in a loaner car. And I usually ask the customer, which one of those would you like to have? And it comes out, I don't ever, you want to give it a plan on me, because I'm going to take care of the customer every time. But we're having a discussion about the dealer plate again. And I understand all these items come up, but to me, I tell my staff, because they want to do that, you bear the responsibility of being in business, whether it's recalls, title problems, anything. It all boils down to the customer, what they want to do, and what best serves them. So that's my opinion on that. So, but the dealer tag, I don't know. It seems to be an ongoing conversation.
it's an ongoing. I would just recommend we just eliminate the letter of warning.
Can I say something? I'm sorry. Denise Lawrence, Executive Director. We did discuss this for a very, very long time. And I think what we relied upon were there are existing exceptions in this section of the statute that specifically say when you can give a dealer tag. And I think in this instance, the dealer tag was provided to this individual for well over a month. That's a long time for you guys to have the liability of someone else. The exceptions might be running, someone who does driver's ed at a high school, maintenance, things like that when a vehicle is brought in. I think that our concern was liability to the dealer and that there are other avenues. The dealer also has the option of contacting someone at the clerk's office at the Department of Revenue to get an additional tag. I mean, that we are happy to help in that regard. Anytime one of our dealers calls us, I'm more than happy to get them in touch with someone at the Department of Revenue. So, I mean, I would just, before we change that, I would really like to hear from Bob Weaver.
Bob, you've been put on the spot.
Maybe this was by design. It's pointing in this direction. Bob Weaver. How about that? Is that better? Bob Weaver, Tennessee Automotive Association. A couple of thoughts. One is Tennessee is in the majority of states where you do not have to have a title present to sell a car. That's the first thing. Pennsylvania, you do have to have a title present, for example. Tennessee, there is an expectation that you'll be able to produce that title in a reasonable amount of time. We can argue about reasonable until the cows come. In this instance, I'm just hearing bits and pieces. It sounds like the dealership issued a drive-out tag under the authority of the commissioner, given that second 60-day drive-out tag. They issued a second tag. And so his option was, do I issue a third in violation of the rules, or do I put him under a dealer plate, which I understand I'm taking the liability then of letting them operate under my tag? Well, that's my decision. Now, the dealer plate can be used by an agent or an employee of the dealership. If you do that, then I would strongly encourage the dealership to make that person an agent of the dealership while they operate that car. I would do that under very limited circumstances, just because of that liability exposure that you're doing. But under the hand that we're dealt, 2 60-day tags, I think sounds like the dealership was taking care of the customer. Now, could they go apply for a temporary operating permit? Yes, that's a dispensation that has to be authorized by the Commissioner of Revenue or his designee, and that is a possible option. But I agree with the statement that was made. I doubt that very many dealers know that option's out there. There are exceptions to the dealer plate use. If a car is in for service and a dealership is able to provide a service loaner, as long as a charge is not being made for that vehicle. If it is a true rental, then that car has to be plated under a
Thank you.
Quick question, Mr. Weaver. Does the 72-hour rule still apply for a dealer plate? So we're talking 72. I mean, but you're saying it's under
the
our
statute still
restriction.
says that if I come in to look at a car and you want to allow me to drive off that lot without having purchased the car, the statute still allows me 72 hours to let me use that car to demonstrate that car over the weekend, let's say, and then bring it back. That is an allowable use. So that's one of the allowable uses of a dealer plate. Driver's ed was mentioned. There are several other exceptions in that particular statute. Oh, but
I don't
again,
know what the exception is, really. We're living in a world right now where things are just waiting, on hold, back ordered, COVID, whatever. And so we have to,
particularly when you're dealing with trying to get, when another state's involved, that increases the difficulty. But if I trade my car in to you today and I'm a resident of California, you know, you're going to have that situation where you send the money to pay off my trade in, and then a person wanders in and says, I like that car. You can sell that car today and hope the title work catches up. That's the whole issue. That's the whole thought behind the Truth and Mileage Act and the secure power of attorney.
Well, we could go on and on, but I think in this particular case, I think the customer was just helping, the dealer was just helping the customer. I think we just ought to just eliminate the warning.
I don't know that.
And just, I went back and looked at this since we're talking about this. I wanted to give you a little bit more detail. It was a little over a year that it took. So, yeah.
Oh, well.
The letter of warning is still justifiable.
Yeah, the warning
Okay,
still
well,
justified.
there you go. I'm
That's
with
my
you
vote.
on that. Okay.
Okay.
All right. So,
Thank you for the
Let's
investigation.
move on.
All right.
Absolutely.
Right. Just to clarify, since we are, I just want to make sure for mine, this is similar. It took a year to get the title. That one took 10 months, and we're doing a fine on this one and a letter on this one. So I didn't know if we wanted to change the other
No,
one.
we're going to keep it.
Okay.
Okay, and one last one is case number
What are we
78.
doing with this?
Keeping a letter. That's why I was trying to say, because the
Okay.
one that took 10 months has a fine. This one took a year, and it has a letter. So I just didn't know if we wanted to change one or the other to make them the same, or.
I think it's because he used the dealer jag for a year.
But it took a year to get the title too.
Yeah, but
Okay, I was just clarifying.
he wasn't in any trouble because he had a dealer jag.
Okay. Just wanted to clarify that they were consistent.
And I will make it very clear in this letter the other options and what the Department of Revenue's dealer tag states. So they know it's only 72 hours and these are the exceptions.
Okay, and my last one is number 78. Apparently, the respondent's license expired on 8/31 of 22, and we are fining him $2,500 civil penalty for each month. My question is, how long do we keep fining this dealer, you know, for the license? To me, doesn't seem like he's going to pay it. Should we do some other investigation or maybe just eliminate his business totally? I mean, what's going on here?
Well, in this case, they're still running. I mean, we'll close and flag something when they've shut down and they're expired. We don't bother finding them. But because this person's still up and running, you know, this is how we can, we want to take action so we can shut them down one way or another and also penalize them if they were to try to get a new license. Because they're going to have to either get a new license or we...
That's just it. He's not responding at all since August, correct?
Right. I mean, this is the way we get them to respond, I think. I mean, did you have another idea as to how we can go about
I'm just
it?
curious why he hadn't paid. I mean, I know why you're doing it. It's just, I guess.
Well, this is the first time we've, you know, he doesn't even know he doesn't know we're finding him yet until we send this out.
I'm clear.
More question?
Okay, I'm going to make it short because we're way over time. On number 2, for our recommendation, don't we need to give a surety bond info for failure to deliver the title?
They have that. Sorry, I should have included that in there.
You did? Okay.
Yeah.
All right. Good deal. And just little 2 or 3 little nitpicky ones I'm not going to talk about. On number 65, I might suggest a letter of warning as opposed to a $250 penalty since the problems seem to be corrected as we would want them to do.
That's fine with me. Whatever you guys
Are
prefer.
you all okay with that?
65, you want to do?
65,
Just reduce to a letter warning?
just to a letter of warning since he did correct the problem, and that's what we ultimately want. Okay? And number 67, what about sharing the surety bond info on that?
I'm pretty sure they've already gotten it, but I'll double check, and if not,
Good.
I'll share it. Yeah.
Okay, that's all I've got.
They send it right away, like in centralized. If it says it there, oh yeah, so they did get it. Yeah. Okay.
Number 36 and 30. I was having a hard time. They tied together.
I am happy to answer any questions you have, or do you want me to try to summarize it for you? Because I know this one very well. Okay, so the respondent in number 36 is a person who used to have a dealer license some time ago, hasn't had it for at least a year, and had the complainant is somebody who knew this person. They were friends, acquaintances. The person that wanted a car knew the respondent used to have a car business. So the complainant approached the respondent and said, I want this car. Can you find me this car at an auction? Not knowing that the respondent no longer has a dealer license, because this respondent is a criminal. I mean, it's very clear. So the respondent took the complainant's money, went to another dealership, bought the car under a false dealership name, put a down payment on it, and then never paid it off and kept the complainant's money, and that dealership repossessed it from the complainant. Does that?
Remember, I had to read that one 3 times.
Yeah.
I'm sorry if I did not explain that well. I apologize.
No, you did. It's just a weird
It's crazy,
scenario.
right?
I'm like, wait a minute, they paid $15,000 deposit, and then somebody says they didn't pay anything for the car. And I was just
Right. I think the complainant gave the respondent considerably more than $15,000.
Does anyone have any question about this last one that we just got, the paper one we just got? Everybody okay with that one? Okay. All right, with that said and done, no more question.
Just one more thing. Did everybody get the addendum? Oh, I'm sorry. Okay.
Yeah, that's what I said. Okay. All right. With that said and done, do we have a motion to adjourn subject to the full commission?
So moved.
Second? Second. All those in favor of the motion, signify by saying,
Whoa. Mr. Chairman, I think we need, the legal committee needs to adopt the report
okay.
after Commissioner Levy has a question.
Take your motion back.
Motion retracted.
Okay, and the second is retracted. All right, now, do we have a motion to accept the legal report subject to the full commissioner adoption?
So moved.
Second? All those in favor of that motion signify by saying aye.
Aye.
In opposed, ayes have it so ordered. And we are adjourned.
We'll take a quick recess, and we'll be back with the quarterly meeting, and hopefully it doesn't take as long.
Oh, wow.
Before we get started this morning, I would love for us to hear from Commissioner Watson about how his family's doing now that he's recovered.
Oh, thank you. Everybody's doing well. Kennedy and Clayton both are starting their second semester at TCU. We started on time. In fact, she was released from her wheelchair and right before we left for school. So she's doing well, finished her PT and healthy and just kind of regaining her strength and doing everything freshman girls do. So
I think everybody would just like to hear a good outcome.
well, thank you for your prayers and support.
Yeah.
I appreciate that.
Okay. Also, before we get started, we need to add the agenda left off an appeal for salesman's license. You want to tell us about that just real quickly, just what the name is?
Michael Sullivan.
Okay.
I'm sorry. Michael Sullivan is our only appeal today.
Okay.
John Michael Sullivan. And I apologize. We just inadvertently left his name off of the agenda, but should
Well,
be
when
in
we
new
adopt the
materials.
agenda, we'll be sure to have that added to it. Okay, the meeting is now called to order at 9:45 a.m. on the 23rd. And would you call the roll, Executive Director Lawrence?
Absolutely. Can you hear me?
Yes.
Commissioner Andrews is present. Commissioner Barker
Present.
is present. Commissioner Elam is present. Commissioner Evans, Commissioner Galvin,
Present.
Commissioner Jackson
Present.
is present. Commissioner Kramer
Present.
is present. Commissioner Levy
Present.
is present. Commissioner Lee is absent. Commissioner Melton is present. Commissioner Norton
Present.
is present. Commissioner Speaker
Present.
is present. Commissioner Vaughn
Present.
is present. Commissioner Watson
Present.
is present. Commissioner West
Here.
is present. And Chairman Roberts.
Present.
Mr. Chairman, you have a quorum.
Thank you. Meeting notice was sent out, correct?
Yes. And this meeting's date and time and location have been noticed on the Tennessee Motor Vehicle Commission website, including as part of this year's meeting calendar since November 20th of 2020. Additionally, the agenda for this month's meeting has been posted on the Tennessee Motor Vehicle Commission's website since January 16th, 2023. This meeting has also been noticed on the tn.gov website.
Okay, we need to adopt the agenda for today. What's your pleasure?
This is Commissioner West. I move that we adopt the agenda with the amendment of adding a salesperson appeal.
Second.
Mr. Jackson, second it.
Further discussion? All those in favor say aye.
Aye.
Opposed? Okay. We need to approve the minutes, and everyone was emailed that info. So what's your pleasure on the minutes?
Commissioner Barker, second.
Okay. Any further discussion on the minutes? All those in favor say aye.
Aye.
Opposed? And now I guess we'll go into salesperson appeals. And who wants to present that to us?
That'll be me.
Okay.
Hi. Oh, thank you. Good morning. So Mr. Sullivan had applied for a salesperson's license with us in November. In his application, he had also selected that he had a previous criminal conviction, which when normally that happens, we request further documentation, which he submitted. That indicated 2 charges of petite theft. The latest one was in 2019. And the way that our statutes work and the way that the Fresh Start Act works, basically, the legal team decided that based on that, he would not be eligible for licensure until 2024 because a crime of theft is something that we take very seriously. It directly relates to one's fitness to practice within occupation. There's the concern about knowingly depriving others of their property. There's that concern to customers, to the, having access to the personal information, having access to like property. And so that was a concern here with that kind of a charge, which is why Mr. Sullivan was subsequently denied. And as I understand, he's here today appealing and wishing to address you. If there's any questions for me, let me know.
Yes, I've got one. Is this something we can do? Or are we prohibited from giving to granting him a license today, or do we have to wait till 2024?
But you can.
We can, okay.
You can absolutely approve him today,
Okay.
If that's your desire.
Let's hear it, and if he will come up and address us. If you'll go to the little station there. Tell us your name, since we don't have an agenda with your name on it. Just tell us about yourself and what happened and things that would be pertinent.
Certainly. My name is John Michael Sullivan, Sr. Just moved here from Florida. I've been in the car business for the past 15 years, better part of the past 15 years. Most of that's been in sales. I've also worked on cars my entire life. Those charges, the first charge was from a long time ago, back when I was a single young man and made poor decisions. The second charge was simply something I wish I had taken to court and taken to a jury trial. However, my wife was very ill at the time and going through endometriosis and having a gallbladder removal, and we had a young child at home. And I just did not have the money, time, or resources to really put the time towards it, and it wasn't affecting my career in Florida. There's no such thing as a salesman license in the state of Florida. I was still working as a salesman every single day. So I went to court, and they offered me a plea. They said, if you plead no contest and pay this $500 fine, you'll never have to worry about it again. Just sign right here. If not, you can take it to jury and move on and move on and move on. And I said, I just want to be done with it. So I paid the cost, and I've never thought about it since. It was the day that happened. I had taken my wife out after her first endometriosis laparoscopic surgery. She hadn't been feeling well, and she had finally felt well enough, so we went to church, and I took her to get her nails done after church. I went across the way to Kohl's with my son, who was about a year at the time, and we were walking through the Kohl's, and I was looking at perfumes, and he must have grabbed a bottle of perfume and put it in the stroller, and the guy came chasing after me and told me that, and he wanted me to come in and fill out paperwork, and I told him I didn't have enough time for that. I had to get my wife across the street. I didn't mean to take it. You can have it. Here you go. And he wanted to press charges anyway. So that's how that charge even occurred in general. I continued. I went to court. I took care of it. I paid fine. Up here, I've actually moved my wife, and I have 2 children now. He's now about to be 5 in May. My daughter turns 2 next month. Moved up here with my wife and 2 kids 4 months ago for a job that I originally initiated the application for this license for. I'm no longer with them. I'm now with Toyota of Cool Springs, and I need the salesman license to provide for my family.
Let me ask you this. I'm just not clear on it. Maybe you said it and I didn't. It went over my head, but it's the one that you pleaded no contest on. Is that the same one where you took the bottle of perfume, or?
Yes, sir.
That's the same thing.
Yes.
There's no other one.
The first charge, I was literally highly intoxicated. I didn't even remember the evening. I woke up and was looking at Facebook, and it showed a picture of me driving out. And it dictated that I had gotten a carton of cigarettes and an energy drink and put my debit card in and never took it out and left. So I went in to pay for the product, and the guy said, "I don't want your money. I want to press charges." And that's what the first charge was. And I don't even drink anymore. So.
Well, there was a first charge.
That was years ago. That was back in 2014.
Okay. And the other charge was when? What year?
So we have one from 2015 and one from 2019.
I'll open it up for questions from the commissioners on the.
Commissioner Vaughn, I have a few questions. Have you been in trouble since this occurred? Did you make full restitution?
Absolutely. That very same day that I was in court. Yes, ma'am.
Trying to think of anything else I have questions about.
Never been convicted of any other crime. I haven't had a moving violation in over 7 years. I'm a contributing member of society. I'm a loving family man. I have 2 small children.
Yeah.
This is my profession. This is what I do for a living. I love the car business. I'm passionate about it.
Have you ever had any complaints related to the car business against you?
5-star Google review.
What stores did you work at in Brevard County when you were down?
Brevard County?
Mm-hmm.
Palm Bay Ford. I worked there. It's another AMSI store. Same corporation I work for now. I worked the first outfit I worked for was Bob Steele Chevrolet when I moved down there from Maryland. That's where I'm originally from.
I know Kevin. He's a good guy.
He is a good guy. Yep. Steele's a good family. And then I worked for Rosner Chevrolet before they were bought out by Boniface Hires. And I worked with Boniface Hires Automotive Group for many years as a finance manager, as floor sales manager, closer.
Commissioner Vaughn, I have one more question. So why did you switch dealerships from the first place that you were going to work?
I had a great position in Florida. I moved up here to become a sales manager at Greenway Kia of Hickory Hollow. And when this salesman license got denied, they took back that offer, I guess, and offered me a BD.
So you're going to be a salesman instead? Is that correct?
But I mean, that's our business to me. Salesman, a floor manager.
You're looking at a bunch of car salesmen, so I understand that.
Any other questions? Bring someone. Okay, we'd like to hear from you. Thank you.
I'm Chris Crable from Toyota of Cool Springs, one of the managing partners over there. I met Mr. Sullivan about 2 months ago. However, he was referred to me by some friends that I've known for 20 plus years in the car business from down in Florida. I'm also from Brevard County. And he came highly recommended based on his salesmanship, based on his CSI scores, all of those things. I dug into how he had been doing performance-wise, all of those things with these gentlemen, and all of them said nothing but great things for him. So when he came to me, he was very upfront and honest and said, here's what's happened, here's my background, here's kind of where I am, and I'm kind of stuck, in this position. I said, I will gladly, come with you and try and see if we can get this overturned and work on an appeal with you and do it the right way.
So I take it you haven't known him very long.
I haven't known him personally very long. Yeah, I just went off of recommendations. And the folks that did recommend him, I trust very well.
Questions?
I have a comment for Mr. Sullivan. In the South, humility is a very honorable thing. And my understanding, when someone comes before the commission and they come from a state that doesn't have a license, we in Tennessee have a license, and we honor that. And we just feel like sometimes that's overlooked, and I feel like you maybe overlooked that in your presentation. So understand you're apparently a professional and done a good job with the companies, but in Tennessee, you know, we do have a salesman license. So, okay.
Commissioner Jackson, I motion that we grant the license.
We have a second. Further discussion. Executive Director, would you please call roll?
Absolutely.
For the vote.
The motion is to grant licensure to Mr. Sullivan. Commissioner Levy?
Yes.
Votes aye. Commissioner West?
Yes.
Votes aye. Commissioner Melton? Votes aye. Commissioner Elam? Votes aye. Commissioner Andrews?
Aye.
Votes aye. Commissioner Watson?
Aye.
Votes aye. Commissioner Speaker?
Aye.
Votes aye. Commissioner Galvin? Votes no. Commissioner Norton?
Yes.
Votes aye. Commissioner Vaughn?
Aye.
Votes aye. Commissioner Jackson?
Yes.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. Commissioner Barker?
Aye.
Votes aye. Chairman Roberts?
Aye.
Votes aye. Mr. Sullivan, your license will be granted. You should get a copy of that emailed to you electronically today. Thank you.
Thank you. Right. Executive Director Lawrence, you got a report for us?
I do indeed, Mr. Chairman, and there is sort of a lot of information on this report. I'll start out with the number of new dealers that we've opened since our last quarterly meeting is 83. We have about 30 applications in process, so we are continuing to just really, the economy appears to be coming back, and everyone is back at work, and we appreciate that. I've listed the number of dealers that we have statewide, and then the number of complaints that we've opened are 69. The number that we've closed are 95. We are in the process of collecting our annual sales reports, and we have really exceeded our metrics in terms of licensure. We are licensing individuals in less than a day, and I can't tell you how proud I am of all of our staff. And speaking of our staff, I know many of you know Portia, and she is expecting a new child in March, so she will be going on maternity leave. So we may have a little downtime in our licensing, but we're all really happy for Portia and can't wait for her new arrival. If you'll notice in the outreach section, I've listed some language at the bottom of that section that we would really like to put on the website, sort of as a bulletin, in keeping with what Commissioner Norton and Commissioner Galvin have noticed, is that we seem to have an inordinate number of temporary tag and title violations. I had forwarded to all of you a story that ran on WSMV. Now, that I think is somewhat unusual. We don't see things like that all the time. But of course, when it's highlighted in the news, then people tend to get ideas. So what we wanted to do was issue a notice to all of our dealers via our website that simply warns them or makes them aware that fraudulent use of a temporary plate, for example, selling temp tags to someone for monetary gain. We have not had a complaint like that, but that was alleged in conjunction with this story. And then placing a temp tag on it that's unexpired onto another underregistered vehicle. Those are all violations for which you may revoke or suspend a license. So we want to make people aware of that. Some language that I'd also like to add to that is just in addition to that suspension or revocation, the commission, you all have the authority to impose civil penalties of up to $5,000 per occurrence. So hopefully this will cut down on what we keep hearing anecdotally, but certainly that's not the same thing as issuing too many temp tags. But that's some language that I would like for us to be able to put on our website, and I thought if I could point that out to you guys, that maybe we could, when we adopt the director's report, that we would be adopting that recommendation as well.
Does legal believe that it's in good standing to do so?
Well, I can speak to the program side. I think there's a lot of concern that we share, and we have talked about this for a while, and have consulted with the Department of Revenue as well. It's just kind of the best way I can describe it is the Wild West right now when it comes to these tags. And so I do think it's really important to put people on notice that we are aware that this is happening, and for people to be extra vigilant about this, because we don't really have access to how the easy system works. We don't know what actually happens once they're in there, but we know some weird stuff has been going on. And so I think that we can anticipate seeing complaints of this sort and this becoming a really, really big issue. Because I know there's some, with COVID and even with just backlog in the industry as far as like metals, like just a simple thing is that, with the plates, like I think that this is not going to go away. And I think Taylor and Erica can maybe speak more about the discipline part. But I think as far as the program side, you have the statutory authority to hold people accountable for that. And this will go to what we talked about earlier about deceptive practices and potential fraud. So it will be that same statute that Taylor was talking about earlier during the legal report.
Well, hopefully what you're planning to announce this with, report will help, but I don't know that many people are going to read it. So if there's any other avenues to get that out.
All right, I can also, what I'd like to do is post it on the website as a bulletin, but what we can also do is I can send out an email notification to at least to all of the dealers who have email, and then we'll also do a print version and mail that to the dealerships. And hopefully people will read their mail.
Yes, definitely. About a big bold letter that says, obey the law.
Yeah.
Well, nothing else on the director's report?
That's it.
Okay. Do we have a
Commissioner Jackson, a motion to adopt the director report with subject to the changes that just outlined to us about the $5,000 in addition to posting on the website, emailing it, and then also mailing it.
Commissioner Vaughn, second.
Further discussion? Executive Director Lawrence, will you call the roll for the vote?
Yes, sir. Commissioner Levy?
Aye.
Votes aye. Commissioner West?
Aye.
Votes aye. Commissioner Melton? Votes aye. Commissioner Elam? Votes aye. Commissioner Andrews?
Aye.
Votes aye. Commissioner Watson? Votes aye. Commissioner Speaker?
Aye.
Votes aye. Commissioner Galvin?
Aye.
Votes aye. Commissioner Norton?
Aye.
Votes aye. Commissioner Vaughn?
Aye.
Votes aye. Commissioner Jackson?
Aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. Commissioner Barker? Votes aye. And Chairman Roberts?
Aye.
Votes aye. Mr. Chairman, you have adopted unanimously the director's report.
Do we have any update on the rules book?
Interestingly enough, yes. This is something that I'm so excited about, and I'm frustrated because we don't have yet. For those of you who don't know, we're having a booklet printed with our current statute and rules so that it will be hopefully easy access. I'd say 5x7, something like that. I wanted them here today to be able to hand out today, but I am told they will ship on the 26th. So expect to see me knocking on your doors at your various dealerships, and I will come bearing good tidings. And then we'll share all those with the county clerks as well. I'll make some trips to county clerks and we'll mail some out.
Very good. All right. Who wants to address us about the legal report?
Yeah, I can do that. We only had 2 changes to the legal report. The first one was number 20, which the complaint number is 2022026821. And we changed the penalty from $750 to $1,250, and also added the requirement that the respondent has to appear before the commission to discuss this issue at the next meeting. And then number 65 is 2022040111, and we changed the penalty from a $250 civil penalty to just a letter of warning. And that is all of the changes.
Commissioner Jackson, I motion to adopt the legal report as adjusted.
Second, Commissioner.
Any further discussion on the legal report? If not, Executive Director Lawrence, will you call the roll for the vote?
Absolutely. Commissioner Levy?
Aye.
Votes aye. Commissioner West?
Aye.
Votes aye. Commissioner Melton? Aye. Votes aye. Commissioner Elam? Votes aye. Commissioner Andrews?
Aye.
Votes aye. Commissioner Watson? Votes aye. Commissioner Speaker?
Aye.
Votes aye. Commissioner Galvin?
Aye.
Votes aye. Commissioner Norton?
Aye.
Votes aye. Commissioner Vaughn?
Aye.
Votes aye. Commissioner Jackson?
Aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. Commissioner Barker? Votes aye. And Chairman Roberts?
Aye.
Votes aye. Mr. Chairman, you have adopted the legal report as amended.
Okay, thank you very much. Legal updates.
So there are some bills that we are currently watching as they're kind of getting put out there. There's one in particular that has to do with publishing agendas and supplemental documents at least 48 hours prior to meetings. But again, Denise and I are watching that as it kind of gets pushed through the system. And there's a few others, but nothing really that would affect us in a practical way. So.
Well, hopefully you'll let us know if something gets on the radar screen, okay? Committee reports, I don't think we have any committee reports, and nothing under new business.
Chairman Roberts?
Yes.
The disciplinary action report, do we adopt that? Because it's on the agenda.
Is it part of the executive directors?
We don't have to vote on it. That's just for your information.
Okay, thank you.
I did have one more thing to add, if I might. This, unfortunately, is the last meeting for which our program legal counsel, Sveta, will be with us. And I'm terribly, terribly sad. We are all going to miss her, but she is moving on to greater things, I know. But I know she's going to still keep in touch with us. We have had such an incredible legal team and these 3 young ladies. I can't tell you how wonderful it's been to work with all of them, and we're really, really going to miss Sveta.
Sveta wasn't with us very long.
Well, I was here longer than you knew, but I just could not. I just want to say I've really appreciated working on this commission, and the work has been very meaningful, and I'm really grateful for my experience with all of you. I am sad that I couldn't actually come to more meetings, but I just I'm transitioning into private practice, and so I hope to keep in touch with all of you. Hopefully, I don't see you on the other side at any point, but really appreciated my time, and good luck and everything. Thank you.
Thank you. So no new business, old business. We can entertain a motion to adjourn.
So moved.
Second.
Yeah.
You tell they got to drive to Memphis.
Yeah, we got to drive home.
I believe that was. I think that was a little faster than the legal report was.